Good morning, everybody, and welcome to this episode of Roll Call on True Crime with the Sarge. I'm your host, Joseph Giacalone. What is Roll Call? Roll Call is when the cops get together for their tours, whether it's the day shift, the 4 to 12s, or the midnights, and they get their assignments from the sergeants and lieutenants to find out what they're going to do for that day. And then remember the famous pop culture reference, be careful out there, right, from Hill Street Blues and Sergeant Esterhaus. So without any further delay, we have a very special guest on a very special day. Joshua Schiffer. Everyone knows who Josh is. Josh, I wanted to wish you a happy birthday, everybody. If everybody in the chat can wish Josh a happy birthday. And we have a cameo already.
Oh, look, she couldn't stay away from you, son. Come on now. She literally came running the moment I logged in. She's like, this is my time. It's
there you go.
Friday morning. It's 8 a.m. Thanks so much for having me. It's awesome to be here on my birthday. And wow, there's a couple things going on.
Oh yeah, just a couple, right? So yeah, right. Just to start off. So I have a question for you. Are you up for this epic opportunity to work with a Sarah Boone?
So
right, because that's how it's described. It sounds like a great deal.
Professionally, it's so intriguing. Like, you gotta understand. So public defense, and when you get into public defense, and I was a public defender at the beginning of my career, I still work with public defenders in a bunch of different roles. It's a calling as much as a job, and there are trade-offs. And one of those trade-offs that is a benefit as well as a challenge is that attorney-client relationship being provided by the Constitution and the state. And that's really kind of a tough employment agreement that most people don't understand, that your right to an attorney, it's universal. It's sacred. But it can also be kind of taken away if you don't know what you're doing, and if you're going to be a jerk, and if you're going to be obstreperous. And that's really what we're seeing in about the most unique version of that ever in Sarah Boone. I've heard of judges removing the ability to have counsel, or at least appointed counsel, before, but I've certainly never seen anything like this.
Yeah, I mean, I think it's been through. I think his 8 lawyers have resigned. I think, right, something like that. So she's the 9th. Yeah, because she's now representing herself.
Yeah, that's the thing. Is all right. So the first couple, think about it, reverse roles with the judge. All right, so you're the judge. You don't have anything to do with picking who the public defender is going to be for your client in 99.9% of the cases. That's because the appointment process is done kind of outside the judge's purview. Maybe they signed an appointment slip or something like that. But really, there's a public defense structure out there that says, oh, okay, so when Steve's case comes in, Steve gets arrested, this is how he gets appointed a public defender. And you get your public defender, and in the vast majority of cases, that's your one and only public defender, and you work with them. Certainly, there have been problems there, and certainly there are clients who are really upset about their situation and really don't want to work with anybody, let alone some lawyer they didn't get to pick. But that's happened thousands, hundreds of thousands of times. There's a system all set up for, oh, okay, you don't like Josh? All right, well, tell me why. Okay, so you don't like Josh, let's get you another lawyer. Let's get you Franz. But the system's set up for that. And Franz knows at that point that they're walking in as substitute counsel, that there may be something going on with this client that you're appointed to represent, but didn't choose you as their lawyer. And that's a very specific dynamic, as opposed to something like in the Karen Reed case, where Karen selected these lawyers out of every lawyer in the nation and paid them a ton of money. It's a totally different dynamic between client and representative. So with Sarah Boone, went through one, got kicked. Okay, fine. We're ready. Here's your backup. All right, the backup ran into some problems. All right, so we're going to have to do another bit. All right, now the backups run into problems. Very quickly, everybody realizes, even though they don't have the specifics, where the problem lies.
Yeah.
And that problem lies with whatever's going on in Sarah Boone's head. And that isn't incapacity, because there hasn't been any issues with her not being able to assist herself. She's certainly oriented to time, place, manner. She acts and works with people on a regular level. There's not really big questions there, but she's now plowed through these 8 lawyers. By the time you're on 5, everybody knows that this is an issue. So they're not sending rookie, inexperienced, unprepared lawyers to go meet with a major high-profile case who's chewed through lawyers. No, those lawyers knew what they were doing. So my opinion is that Sarah Boone has found some magic words or circumstances that when she discloses them to whatever lawyer, that lawyer is no longer able to continue working because these lawyers have asked to leave. And in every case, judge has been like, okay, you're out. Right. Now, the judge does not want to let that happen. The judge wants to move the case. So for a judge to get to this point where they're going to try Sarah Boone without a lawyer, with, as far as I understand, really not even backup counsel, it's really shocking. And I thought it was a fantastic snippet yesterday of Sarah Boone's strategy kind of working, where there were some conversations between the state and the defense that the defense should always be in on. And Sarah Boone turns around and says, hey, I don't have a lawyer, so I get to be in on these conversations. And how messy she can make it, because that's, looks to be the goal. That's really going to be this year's essay question on the terrible client bar exam.
Yeah, I mean, listen, I have never seen something like this happen in real life. In regards to some of the cases and stuff that we were working on. So to me, I'm watching this, I'm going like, man, this is absolutely off the charts. Now, can it come to a point where they're going to say you have to take a lawyer? Could that ever happen?
Can't force. So the judge can assign, but look, think about the remedies that the judge has. So Sarah Boone's competent. So that incompetency part that normally goes along with some of these can't cooperate with their lawyer, can't assist themselves, that stuff's really kind of off the table. She doesn't get to claim that. Whatever her issues are outside of her ability to be a defendant. And so while the state and the court will ensure that your floor of rights is going to be met, they don't have an obligation, nor do they have the tools to guarantee a lot more over that. The court can't obviously force Sarah Boone to say things because that's a violation of her constitutional right. They can't force her to really do anything but appear in court. And that's generally the remedy for non-cooperative individuals. They assign them a lawyer. Most of the time, the person doesn't want to work for the lawyer. And they parade you into court tied up, and they say, hey, you don't have to do anything but be here, because that's the fundamental requirement. But you don't have to really participate in your own defense other than being present and allowing the court to make sure that you understand what's going on, even if you're not going to be compliant. In this case, really, though, is different because Sarah Boone has objected, has told them to stay away, has begged for additional lawyers. That poster that she drew, the flyer, is a work of immense art, in my opinion, because no one has more beautiful expression than folks who are locked up. And I think it's basically a piece of pop art right now, illustrating her juncture very uniquely at justice, in the justice system at this moment. And I believe the judge is going to keep moving. This case does not stop. If the judge gives up the calendar, it's allowing the defendant to control the system. And that's not the way the system's set up. It's not fair to the other people involved in the system to allow one party to dominate the calendaring like that. Even though every DA in the nation does that, not supposed to let the defendant do that. And the judge is going to force her to move forward. And it's just going to be bulletproofed and extra difficult and a lot more explanation and ensuring that a huge record is compiled, because the judge looks at Sarah Boone and goes, I got to try it. I got to get a verdict, and then it can go off to the appellate courts, because that case does get appealed.
this case is going to end up in lots of different textbooks, it looks like, right? For judges, for defense attorneys, prosecutors. I mean, because it's going to have to be handled from different angles all over the place. And other people might try to do the same thing, right?
100% other people try to do the same thing. When you get into the real extreme of people involved in the justice system, this is exactly like you're talking about. It's a teaching moment. This is an opportunity to learn. This is an opportunity for judges, prosecutors, and defense attorneys to practice on a real life, extra rare situation. That's why we cover. That's why we're so interested in these super rare events, because this is where the policies and the learning and the pathway gets formed. Our justice system is a living organism. And when we get these new novel issues, how we as a system react to that it is what drives the entire system forward. So, for example, I guarantee there are some jurisdictions that take a look at the Sarah Boones of the universe and go, y'all are insane. 9, 8 attempts at getting a lawyer? No. If you don't like the second lawyer in my jurisdiction, you're on your own. And they probably have some backing for that in their local, whatever their state's appellate courts and body of law represents. But then there are other states that probably have a much more strong either common law or statutory format requiring the participation of the lawyer and all that stuff. So it's definitely going to be shared. Judges are going to learn from it. Lawyers are going to learn for it, because we as lawyers at our lawyer conventions for the defense side need to learn. Hey, we have a competent person, which means while we as lawyers have discretion over a couple very specific junctures in the criminal defense process, a lot of what happens is up to the client. And we have to react to it and respond to it, because we can't control the client. We as lawyers get to make a couple very key decisions and govern strategy. But doesn't mean the client has to listen to you. And you have to be prepared for a client that isn't going to listen to you, because you have pre-existing ethical obligations to the court system. Remember, that's the wedge that a lot of people don't understand. When the judge does something, they've got their rules and ethics. When the state does something, they've got their own rules of ethics. Same with the defense team. Independent of whatever Miss Boone does, her lawyer still has ethics. And now we've got a succeeding series of lawyers who all have obligations. That one of those obligations obviously is confidentiality, but there are exceptions to confidentiality. Lawyers are actually required to spill the beans under very limited circumstances. And there's a lot of you can or cannot spill the beans or violate privilege, depending on what the client has told you. And those exceptions have been developed over time in order to protect the health and well-being of the public, in order to ensure that people's constitutional rights are met. But if a Sarah Boone in the world is telling her lawyer certain things, it justifies a lawyer withdrawing without really telling the court much. If Sarah Boone is telling the court or telling their lawyers other things, those lawyers have an obligation to share with the court if someone is in immediate harm, or there are other very specific factual determinations that get made. And a judge listens to those and then grants the order to withdraw, which they've done 8 times, which leads me to believe whatever Sarah Boone is telling these lawyers has made it to the judge. The judge knows about it, has warned up the incoming lawyers, but it's also so important that there's not been a question about letting the lawyers out. So I love the speculation on this one.
Yeah, I'm sure like the judges at this point be like, yeah, let me guess, right? And then and probably just say whatever he's going to say and then move on to whatever it is.
But think about Sarge, like, all right, so you show up at roll call and it's like, hey man, you're going to go do this project. This is what your duty is today. Yep. By the way, let's just tell you in advance, here are the 5 crazy ass things that you're going to have to deal with going in. Judge has now done this. Let's give him the first 2 lawyers 6 times, and 6 lawyers 5 lawyers, 7 lawyers have gone in knowing, hey, there's something up, maybe even knowing the specifics of what's up. And Sarah Boone has placed them into such an ethical quandary that lawyer said, hey, even though I knew all about this and I went in with open eyes and I can't do this. That's
it's
huge.
I mean, God only knows. I mean, do you think eventually it'll come out? What was going on?
I kind of think it has to, just because the interest level in it, and I don't think now that the court has gone through the very specific record establishment to remove her right to counsel, because that's what the court's worried about. Court's worried about when somebody appeals, are they going to be able to disturb these rulings removing lawyers? So they've gone and researched it, made sure all the documents are in order, made sure whatever rulings and findings there had to be hearings, make sure that record's perfected. And the judge, they're going to end up punting this because they know it's coming up on an appeal, so they've got to keep moving. And the judge has this minefield pathway. All right, I'm a judge. I got to get from point A, which is I got an indictment and a defendant, to the end of the pathway, which is I have a verdict or ruling from a jury. I know Sarah Boone has put out these landmines. I know the state has put out these landmines. How do I, as judge, shepherd this case in front of a jury through the process with a less than cooperative and now unadvised, competent, but unrepresented individual through the complicated trial process in order to get to a verdict? Because that's really the obligation of the judge. I got to make sure that this trial happens. So they're going to belt and suspender everything. They're going to bulletproof every single step in the process is going to be done arguably with a little bit more formality than normal. And at some point, Sarah Boone is almost certainly going to try additional attempts to disrupt the prosecutorial process because she certainly knows what she's doing. And how the court reacts becomes the onus and what the focus is, because the focus isn't going to be necessarily, I'm going to win the case. It wasn't me. I didn't do it. He needed killing, the 3 traditional defenses at law. It's going to be, you can't convict me because I'm going to break your system. And that's a really unique pathway that some clients would take. Lots of people have tried to break our system. Our system has resilience built in because the remedy is always, all right, we're going to hold you in jail until we figure out what to do with you. And I don't think a lot of people understand how much time they have to hold you in jail. They're not going to run out of jails. They have yet to run out of jails anywhere near where I live.
Yeah, it's definitely going to be one for the record books, I'm sure. Everybody, I mean, I can imagine when you mentioned at these conferences, right? I'm sure this is going to be like one of the top discussions for sure.
Oh yeah, like one of my jokes with the true crime community is it's how much of a mirror it is of the lawyer community. We have our gossips, we have our conventions, state and defense and judges. Talking about YSL, perfect example of that. And this is something Joe and I talked about briefly before starting. YSL went from being, oh, that's kind of an interesting case a few years ago, to one of the most, it's an embarrassment as a Georgia lawyer and taxpayer and someone that really loves our system to see this much waste of public resources and problems arise that I and the vast majority of other people find should have been dealt with in another way. And that's being polite. Other judges in this state have been watching that case because they can't move forward with their cases. Judge Glanville in the YSL case basically took a half dozen or a dozen of some of the best lawyers around and iced them for a couple of years. And you'd show up at calendar calls. And they'd, is Mr. Weinstein in? Nope, Judge, he's YSL. He's YSL. All right, let's put because the judge turns around and goes, I'm never going to get this lawyer in here. whatever cases are attached to the lawyer, stop them. They're on pause. And more importantly, or as importantly, same with co-defendant cases. I've actually got a co-defendant case with Carrington Matthews, who's one of the well-known defense attorneys in YSL, one of the more quiet ones, an older, more mature, deeply respected gentleman. And the judge knows that we're never getting my co-defendant case to trial because even after Mr. Matthews is done representing in YSL, there's 2 or 3 years of cases in the chute that they're going to have to deal with. And the slowdown has been huge. So what does the judge's listserv look like? I don't know absolutely, but I can guarantee you that Judge Glanville has heard it from more judges unsolicited than he ever expected. Plus, Judge Glanville's been a judge for a long time. He's known. These are his colleagues and buddies. You don't think that he was getting his balls busted, pardon the French, harder than you'd ever imagine. So, Joe, you're a cop. You guys all, if you see somebody do something that was just head-shakingly bad, everybody's going to talk about it, right?
Yeah. Of course.
That's what's happening with YSL.
Yeah, and this is, I think, the longest criminal trial in Georgia history now. I put it as a poll, whether it was yes or no. It is. It's the longest criminal trial now.
Yeah, we had this big teacher trial, but jury selection YSL was a year. We're not even halfway through the state's case, and the state has gotten a lot of wins out of this. Don't make it seem like the state hasn't chalked up its share of victories in YSL. A lot of people pled. This started.
Happy birthday to Josh with the good glasses. Thank you, Jake.
Yeah, well, the YSL, Fonnie Willis has succeeded in some ways by attacking this organization, Young Slime Life, in whatever ways. She has gotten a lot of pleas, but the resource use and wasting calls into question our judgment of, is this the way that justice should proceed? Because look at where we are now in that case. Judge Glanville has shepherded through to about halfway, third of the way through the state's case. The state has the burden. There's a half dozen main defendants left. They're all have a jury that, first of all, took forever to sit and now is still on the clock with almost no guidance. When a jury's out like that, they're learning about the case, hearing about the case. There's threats to integrity of the case. So you've got this jury out there. You've now had a recusal, so the jury's going to get a whole new judge, whole new judge's staff. You've got the obligation of Judge Whitaker. She has to learn this stuff, which means she has to get transcripts, which could take forever to put together, and then pick it. So there's all these problems, and the critique from other judges, the critique from other prosecutors and defense lawyers is, how did we get to this juncture when another judge has already sped up the process dramatically? And in other jurisdictions, there are judges who could try this case in a much more efficient manner that wouldn't have made it appear, as it did with Judge Glanville, that the state was getting to stick their thumb on the scales every day. And that's part of the analysis that's coming out of YSL, is not only did Judge Glanville fail to keep the case on the straight and narrow, on a tight track, and he's a deeply military guy. This guy's been in the military his entire career, highest ranking military judge in the nation. Guy knows how to move business. How did he let this case slow down so grossly becomes the magnifying glass for his treatment of the state in allowing the state to present this case in such a grossly messy, wasteful, ineffective, time-consuming way. And how all that gets put into the blender, spun around, and what happens with these defendants, still giant question, because if a mistrial happens and the state preserves their ability to try these guys, they're going to sit in jail another 4, 6, 8 months before they even restart the trial. And then talking the guys being basically on trial for 5 or 6 years. Now you get to fundamental notions of fairness. Constitution doesn't say that's unfair. Here's the factual scenario. Constitution talks about what your rights are to a speedy and public trial.
It doesn't give a length, right? Doesn't once it starts.
No. And we've got a Supreme Court right now that's very originalism centered, and we can talk all about originalism. The basic concept being what the founding fathers and signers said. We're going to go back to what their context is and their usage of the words, and we're going to stick really tightly with that. And we can interpret that and extrapolate out for that, but there's such things as a speedy trial. Constitution lists you have a right to a speedy trial by your peers, and it's been litigated a bunch of times. I don't think it's ever been litigated like this. I don't think it's necessarily fair for someone to sit in jail for 5 or 6 years going to trial. And is that fair? So what do? Do you bond them out? Does bond really solve that problem or address that problem? Bond certainly changes the pressure on the defendants. As you know, if you're locked up, it's generally a lot easier for the state to extract some sort of resolution they want. Bonding out of jail gives a huge benefit to the defense because they've got the time and space to work on the case, and you're not going, oh man, if I take the plea, I get to sleep in my own bed. And that's part of that leverage of plea negotiations that we deal with all the time. And that's been hard in YSL because the YSL defendants are both facing outrageous time or other convictions already. So how their incarceration status affects their decision, man, it's fast. And sorry, I'm rambling. I'd literally talk about this case all day.
No, I mean, I haven't followed it as closely as some of the others, but I've been going back and forth to it just because of all the things that would move, like the judge getting removed. Then there was an interim judge who then had to recuse herself. And then there's another judge now. Oh, my God. Do you think this thing could just, at the end, just fall apart and they just say, that's it, we're done?
Well, that's the big question. So Fani Willis obviously has a couple high-profile cases going on right now that she's had a couple struggles with. And this being a huge one. Remember, this took an entire Superior Court judge's trial and removed it from dealing with all the other cases. Took one of our big ceremonial courtrooms. Took it out of circulation. So there's a lot of people saying, hey, I don't care what you're doing, Fani. Well, the time has taken too long. It's too wasteful. And there's a strong opportunity for the defense right now to force the state to rethink their strategy. What really, for people that too long didn't read, here's where we are right now. The first half of the trial is in the books, and now a new judge has been assigned. The defense has come out and said, due to all of the problems, and there were hundreds of problems, hundreds of different appellate issues, fairness, not fairness, recusal, the ex parte meeting, all that stuff. Due to all that, Judge, we're asking for a defense mistrial. Now, mistrial ends the case. The question being whether prejudice is attached or not. If the court rules on a mistrial and says, yep, this is too broken, we've got to redo this again, which I think is very likely. The judge can't fix what's already been broken. To try to fix it would be wasteful, inefficient. Judge knows that the existing trial is kind of shot to hell. If the judge grants a mistrial without prejudice, the state gets to go back with the active indictment that it has and either retry it on the active indictment or do a superseding indictment. There's all kinds of different pathways, but the train keeps going. If the judge rules a mistrial where prejudice has attached, the state would then be prevented through double jeopardy of bringing back these allegations and all of the accusations contained within this very large and very sprawling indictment. And that's what Fani Willis is really concerned about most of all. If the case is broken in a way that the defendants walk away, she basically gets tagged with wasting millions of dollars, tons of time, and everything the defense and the progressives and everybody's been screaming at her, it was true. And it's a huge, man, you can bone things at your job. this is a multi-million-dollar, high-profile whoopsie. Whereas the defense, if they can get jeopardy attached and prejudice attached, they have got the brass ring, won and won and won. Other people took pleas, are now going to be pissed off at their lawyers. Brian Steele has been fantastic. Keith Adams has been legendary. Bruce Harvey. These lawyers cement themselves as being heroes in the criminal defense universe because they would have won something that the state wanted so bad. Yeah, it's so personal. You can feel, and I know these people. This ain't friendly anymore. Totally unique.
Yep, there's another. So Cake Spoof from Australia says, "Happy birthday, Josh." Thank you, Cake. So I wanted to leave that one up there. We had just passed the 30-minute mark. If you're just joining us now, we have a trial attorney, Joshua Schiffer, and there's a cameo every now and then of Justice Kiddith. She's around.
They're around. They're bugging the tar out.
So yesterday there's some interesting news came out on the Scott Peterson case that the judge has allowed them to, I think, to test for DNA on duct tape that was found on Lacey Peterson's body. What say you on this?
So here's I'm a private lawyer. People pay me to do things. I advise them very honestly. Oh yeah, no, I totally understand that. Let's go do that. Or, man, that's not really the best way to spend your resources. And what really Peterson is it's an exposure of how resources can continue something that otherwise disappears. There's this duct tape. Is there DNA transfer? Man, it's duct tape. There's all kinds of stuff we're learning about DNA. DNA has advanced so much with how little they need, how expansive it is that we're finding your DNA ends up everywhere, man. Your DNA, you're sloughing it off your body 24 hours a day. It's like a little nuclear cloud following you, dropping your DNA. But really, does this move the ball factually for Peterson any more than any of his other prior attempts? No. And this isn't a smoking gun that's that's it. We got to go redo this again. And Peterson has time and time again been denied. Now, I'm not commenting on whether that's fair or not, but he's lost the vast majority of these efforts. And if I'm the judge and I see, all right, you want to test another thing? Great. We're going to allow you to test it, but there's got to be the other half of that coin. Scott Peterson can't create fictitious or frivolous motions. And I think that's kind of where the court is getting with him. So they're going to let him do it. I hope that for whatever reason, the DNA comes out and it says what it needs to say. But you all recognize that every time the court opens up the idea of new evidence, the evidence is only half of what's happening. Court's going to get the evidence. The court's also going to accept that there is a new bit of action, and any action, interpretation, following a direct, taking steps, whatever it is, any action then creates something more to appeal. And the system will just keep eating and eating and eating. There are ways to bring up new motions and new evidence in every state. Years after, there's untimely, there's habeas. There's so many different things that if you can file it, go for it. Peterson just happens to have pretty good lawyers who are getting paid, and they're going to keep filing stuff until Peterson dies or is released, because they're never going to run out of things that you can keep filing, and courts understand that. So if I'm a court, I probably take a more progressive, hey, go test it. Go test it, and if you want to create issues, we'll look at it. But there will be consequences to frivolous actions and wasting the court's time. And that's always a challenge in a criminal context, especially with someone who's been sentenced to never get out ever.
I mean, to me, it's a big chance, right? So if the body was found in water if it was in there for quite a while, the chances of finding DNA probably are slim. And what happens if they come back and say no DNA? Right?
It's the ultimate grasping in straws. It's, hey, we have gone down every path, and at the end of it, man, we are getting shut out. We are getting shut. So you keep finding new and additional pathways. And it's really one of the things we think about when we're doing innocence work. There are people that will profess their innocence, and then you go through the process, and then at some point it's, oh yeah, no, really, I just was fighting because I need to fight, and it gets exciting. There are clients who their fight for innocence never dims. And there's a real benefit to that because, first of all, you can wear down the state over time. If you appeal enough things over enough years and have enough toothsomeness involved, eventually the state may get to a person within the state who goes, hey, listen, let's just figure out a way to end this permanently. And a lot of people are released on resentences and things like that. But the system will also just allow people to keep litigating it ad nauseum and keep the lawyers and the appellate people busy. I think it's kind of wasteful. We'll see where we end up, but there's always something that a more innocent feeling client can continue to bring up and continue to bring up and continue to bring up. I expect that from Peterson, and regardless of what happens, he's going to keep pushing for the innocence story that he's telling people.
Yep. Well, we'll be watching that closely. So we got about 14 minutes left, Josh. We have two things I want to talk about before we leave. So I'm going to give you the choice: Karen Reed or Ashley Benefield. To start off with, I want to talk about both of them. So let's just split the time.
I went to undergrad in Worcester, Massachusetts. I know Massachusetts. My roommate from college, who's now a professor, is from Plymouth. I know this Reed case, and I know the people of Massachusetts. Like, to us on the outside, we're all like, I can't believe this is it. To them, oh no, this is small town politics in Massachusetts. These people have known each other for generations. You've got a mix of old America, new America, townies who have been invested in these communities for generations, where people don't buy and sell houses. They just inherit family members. People where you see these cousins and these pizza parlors. And then you insert some of the journalist bloggers who have an interest not only in the truth. And I know people are really upset with the way some of the coverage and the media interacted with justice and whether the outside noise affected the court. We all know that the jury says we heard the protesters outside. But like the mess that's happened, not a surprise to people that live in that part of the universe, because the cops, man, there's a lot of corruption that runs through Boston. Just is. You've got small town crookedness that's going to exist in every single town in the United States. I love this case. We could talk about anything you want in Reed. Meanwhile, Benefield today is hot because here's where we left yesterday in Benefield. The state has closed their case and provided as much burden as they feel was necessary and that they could produce in the state's portion of the case. What do we know? There wasn't a whole bunch of awful stuff that happened before. We know that there was some really inexplicable stuff that's happened after. We know that she has apparently not told anybody what's happened. So the state did a very good job of two people enter, one person leaves, and she's the one that left, and he's dead. So guess what? You're a murderer. For a lot of people, that's it. It's open and shut. She now has the opportunity to carry her burden, but then you go to the individual jury instructions. And the instructions in this particular case actually don't give her a required defined burden like in other states. Under their jury instructions, and I had a discussion with Tim Panic about this, she can proceed with an affirmative defense without presenting a necessary burden or testimony. She can rely on the state's lack of proving beyond a reasonable doubt as her affirmative defense. And that's not the way that we do it in my neck of the woods or a lot of other places. You have to present some evidence in order to carry your burden on an affirmative defense, because that's the definition of an affirmative defense, is you are putting out information saying, I had a reason to do this, justification, whatever you're going to claim. So today, the jury's showing up right now. State's case is done. If she gets up and testifies, that's one pathway. Or it's Friday. She doesn't have an obligation to present evidence, and they may move directly to closing arguments. Has the state carried their burden, and has Ashley Benefield provided enough to permit the jury to find that she acted in some form of self-defense? And it's not beyond a reasonable doubt. It's really, they get to consider it when deciding whether she's overall guilty or innocent. They have very little information to make that decision on. All the information came directly from the state. Some jurors in an argument would be receptive to, well, hold on. The rules of this game are that the state has to do everything and the defense just has to sit there. And if the state doesn't check enough boxes, we have to acquit. And Joe, you've been in enough trials. That's the instruction. You have to acquit. If the state hasn't carried their burden, it's a direct obligation, jurors. You must acquit. Yeah. And it's fascinating because this domestic violence, battered spouse, intimate partner syndrome has become, one of the kind of 4 or 5 most important issues of development right now for trial law. We're seeing it work more and in more broad ways than ever before. We just had that verdict, last week or early this week.
Marsha Thompson, I think.
Yeah. She was not under threat. If you were a police officer and shot somebody under this, man, you done murdered some. In the rest of the world, your self-defense or justification has this proximity and the closeness of the threat. There has to be a nexus between the threat and your responsive action in harming whatever the threat is. And the judge had already ruled against her on the stand your ground pre-trial. There was never a question about what was happening immediately before the shooting. She shot him a couple times in the back and a couple times in the front. It was bad, but she walked. Now, she had some great evidence of chronic long-term abuse, and that was key. Got to butter up that jury and make that jury believe how desperate she was, and I think that was very real.
And her testifying helped her too.
Oh, huge. And then we're going to see so much more of that. I believe juries love the law and love words, and man, they will pay so much attention and nod their heads and go, yeah, man, that's the way the Constitution works. Let's just rip that banner. Juries want to hear why something happened. Standing back and hiding behind or using your Fifth Amendment shield, it's fantastic and patriotic and all those other wonderful things. But it does not give the jury a reason to side with you, especially when you have an opportunity to testify. And I feel more and more people are going to stand up and testify regardless of the risks of cross-examination in more and more cases, not just in domestic violence, but in other cases. I feel very strongly that juries expect more and more every year to hear from the accused. And what we keep seeing is the jury forgives what we used to be worried about. See, when you've got a client, you're advising them about whether you're going to take the stand or not. The fear is, man, you're open for cross, and that prosecutor, they're going to bring both barrels. They're going to bring up every bad thing, and they're going to make up lies. And then as the practitioner, you're like, how the hell is my client going to perform under cross-examination? Because until you've been cross-examined, you don't really know how well you're going to come off with being questioned in public on the record. There's big risks there. So you've got this huge calculus, and we always hit, no, we're never going to put the client up. They're going to bring up that arrest from 5 years ago. They're going to bring up your prior bad acts. They're going to bring up all kinds of just gossip and slant because they get to. So we always told, no, man, you ain't getting up. You ain't getting up there. You're going to destroy your case, the case that I've worked so hard to prevent the state from winning by carrying their burden, and now you're going to break that. Well, that's changed. Now we're seeing juries that watch a state beat up on an accused and maybe give them a little bit more consideration than they would have 10 years ago about how unfair the cross-examination dynamic can be when there's a professional attorney cross-examining someone who's just a regular Joe or Jane citizen. And guess what? Everybody's done some dumb stuff. If you own it, they'll forgive you. America loves forgiving people. Absolutely. That is part of American exceptionalism 101. We love underdogs. We love people who take a licking and keep on ticking. We love people who keep up the fight. Those are American values. And if you can open up a jury to that, where previously we were terrified, nope, guess what? I'm going to expose my client. We're going to see more wins, just like we did. And that's kind of why I think we might see Benefield testify. But really, my gut is right about, half an hour, 45 minutes, hour from now, we're going to hear, nope, defense does not have any witnesses. We're ready to move to closings. Because when you look at what the schedule looks like, the Benefield jury, it's Friday in my part of the universe. They get in, they didn't close this case today. Friday juries are always a factor because jurors don't want to spend the weekend and mess up the beginning of next week. So you've got this hard stop, and it can benefit both sides. There's two fears that we talk about for juries. And this is one of the key, whenever you're thinking about how and why a trial is happening. Fear dominates decisions. It's the core in you. It's the reptile theory. You have self-preservation built into you. It can never be removed. It is encoded into your spinal column and your brain. You will always respond and react to fear if the fear is real. And you make the fear real. So jurors have two fears. Every juror is afraid of a wrongful acquittal. Oh my goodness, we let that bad man go. Someone who committed a crime, and we failed in our duty to the system to get justice. But, oh no, what about that other fear? Wrongful conviction. What betrays the promise of the Constitution more than an innocent person being deprived of their core fundamental First Amendment right? Life, liberty, property, speech, assembly. That's what a conviction is. It's the state removing your constitutional rights. And you get a juror to go, hold on, and I'm afraid of a wrongful conviction. So we get to the idea of it's better to let 1,000 guilty men go free than convict one wrongful. And our system's built for that. And you get to use that ethic aspect and pathway when you're talking about a defendant taking the stand in their own defense. Jurors love that. You can connect it through your summary and talk about how your defendant faced and got up and talked. You get into fundamental promises and desires of jurors, and it only takes a couple to upset the entire jury pool. And in criminal, last bit, I ain't trying to make 12 people sing Kumbaya and love each other. Going to read and the juror split, whatever you want to believe it is or isn't it. I love a jury that's not getting along. They can sit out as long as they want. As long as they can't come to an agreement, I'm doing my job for my client.
Just a last question here for you, Josh. Do you think because this is actually Benefield, do you think because she wasn't with him for long that might work against the battered spouse defense?
Clearly, Benefield does not have everything that happened like we've seen in the more successful cases. She needs a lot more evidence of prior abuse, problems, etc. She was getting roasted on her descriptions yesterday of the violence that she's made central to the case, because it's not anything close to some of the chronic violence we see in other battered spouse cases. Like, there are people that literally their relationship is built on beating each other. It's horrifying and anathema to the American promise.
Well, Josh, we're going to leave it at that. We promised to get you out here because you're a very
How did
busy.
that go so fast, dude? I'm just getting warmed up. And you're such a saint for letting me prattle on. God, man, you need to get
people are here to see you. They're not here to see me.
Oh, dude, stop it, man. They're here to see you. I'll do this anytime, man. You just call me. We'll this crap all day.
Great. Yeah, no, I definitely think we're going to be doing some Karen Reed stuff. We're going to get back into that. We ran out of a little time today.
Real quick on Karen Reed. Very hard for the Commonwealth to move forward, knowing what's happening with the police officers in the undercover. Whoever prosecutes, Lally or somebody else, has to get up there, and they're going to be required to use witnesses that are flawed and have problems. That makes for a hard case. It sounds like Judge Bev is really going to get screamed at for failing to poll the jury and figuring out whether there was agreement on the counts 1 and count 3. But I don't even know if we get there, because there's still negotiations about what's going on. The defense could be getting threatened with, hey, yeah, we'll dismiss the big ones and just nail her on the stuff that we can nail her on, like the drinking. There's so many factors in that. That's way far from done.
They probably should have done that first time around. All right, Josh, you hang out 1 second. Everybody, you enjoy the weekend. Have a great weekend, everybody. We'll talk to you soon. And Josh will be back. We'll be discussing all this stuff another time. Take care, guys.